benefits of the signing and ratification of African Union treaties, in particular the protocol that is of interest to us, to the Constitutive Act of the African Union relating to the Pan-African Parliament. We're going to follow Professor Magloire Ondoa, who will speak to us about effects of the ratification of the African Union treaties, in particular the protocol to the Constitutive Act of the African Union relating to the Pan-African Parliament in the national legal framework of African Union member states. This is the specificity of his intervention is about the effects and the problematic of the insertion of the international law and the African Union law. You have the floor, sir, Professor. Honorable ladies and gentlemen, speakers, parliaments, I'm particularly delighted to take the floor this morning to speak about the theme, the topic that has been assigned to us, that is the effects of the ratification of African Union treaties, in particular the protocol to the Constitutive Act of the African Union relating to the Pan-African Parliament in the national legal framework of African Union member states. This is quite a long heading. It can appear as being complex, but in fact, it allows us simply to ask ourselves two small questions. What does ratify mean? And after ratification, what will happen? So here are the two questions which we will deal with here this morning, knowing that one of the question is secondary and the other one is important. I must underline here that ratification is nothing else than a sovereign act through which a state, a sovereign state, decides to submit itself to an international text. So ratification is an expression of a sovereignty of a state which decides to profit from the advantages of an international organized system around a certain number of rules. But ratification alone is not enough. The consent of a state to be bound should be expressed not only through ratification, but also through the depositing of instruments of ratification to the competent instances or institutions, that is, for PAP, to the chairperson of the Commission. The debate was referred to yesterday, and we have spoken yesterday about that. The previous speaker has spoken about that, but I would also get back to that, although briefly. I must only underline that once we have underlined that ratification is an instrument of sovereignty, I would like to underline once again an important fact, that is in the text of the African Union and taking on board our levels of regional integration, we have endowed ourselves with mechanisms which protect sovereignty, the sovereignty of the states. This sovereignty is protected because the Pan-African will only work on the themes that have been selected by the Assembly, that is, by the heads of state, and topics which have been approved by the Assembly. This means that the Assembly can suggest and request the Pan-African Parliament to legislate, that is, produce model laws, and the Pan-African Parliament can also suggest to the Assembly topics or areas, and these are themes which are particularly important because they are essential and also common to all the African community. And when the model laws are elaborated, they must also receive the approval of the Assembly. This means that the debate which has very often taken place on sovereignty is governed by the text itself, is dealt with by the text itself. This being admitted, the fundamental issue which we will dwell on is to know what happens following the ratification. The ratification is apparently just a formality, but ratification is also a commitment, a sovereign commitment of a state. This is why we will approach it under two angles. First, ratification has as an implication to see to it that the ratified text should be considered as a national text, that is, a text of national legal framework which binds the country which has committed itself. Likewise, after ratification, there is the implementation of the stipulations of the ratified text. As concerns the first item, that is to say, the introduction of the ratified text into the legal order, here several approaches exist. But two main approaches are common or are recurrent very often. The first approach is relating to the issue to know, meaning that if after the ratification there is need for a national text for the ratified text to be implementable. We have called this in law transposition. In other terms, should there be or not a transposition after the text has been ratified? Some states have chosen the formula of transposition, which consists in saying that the international text has been ratified, but in order for us to ratify it, we must also include it in a national law. This is a formula which has sometimes existed and which continues to exist in what we call the derivative acts, and particularly in some international organizations such as OADA and others. But as concerns organic texts, such as those which are under consideration, that is, Treaty of the Union, is it still necessary to come up with a law on the Treaty of the Union? This formula, obviously, is not the best one, and this is the reason why very few governments have committed themselves. The formula for the large majority, which the large majority adopt, is the introduction into the legal framework. This means that the text that has been ratified remains an international text, but with the particularity that it is implementable in each state. And this is the general principle in terms of international law. And the question was to know whether by ratifying this text we are taking a text which will prevail on the fundamental text of the state, that is the Constitution. Some states say that this international text, once it has been ratified, it prevails over the Constitution. Some states have decided so, and they are more and more numerous. These are states which are convinced of the principle of the regional integration. But others consider that the international text, the treaty that has been ratified, prevails on the national law, the law that has been passed by the Parliament, but below the Constitution, meaning that this is an intermediary text between the Constitution, which is the norm, the fundamental standard, and the law. So the second text is the strongest in the state. This is the position of most of some African states, which whose number is increasing. The choice of laws is important. If we choose to see to it that the voted text has a value of the Constitution, then we would consider the text that has been adopted at the highest level of all the texts of the state. But if we locate it below, it means that this is the second important text. The importance of all that resides in the fact that when a state has committed itself, when it has ratified, it has committed itself as a consequence, according to the position of this text. All the texts which come below must be attached to that, must be subject to that. If we decide that the treaty prevails on the national law, then national laws must every time respect this treaty, abide by this treaty. And this is the position which is adopted in most constitutions of the states, because here we must underline it, it is the national constitutions which determine the place of the treaty in the legal international framework. And this place is this position fundamental, because more a position is high and prevails in the hierarchy, the more the state, that is a rule of law, as we all consider ourselves, and the more a law based on the rule of law is respected. This is essential. This is essential because the ratification is a commitment that has been taken to implement an international text. This is a free commitment. This is a sovereign commitment. This is a discretionary commitment. Each state takes this commitment based on its interests. And our interest today is obviously that the African Union and the Pan-African Parliament be in motion, and that this Parliament deploys itself so that our population and ourselves take benefit of it. So once we have ratified, and once we have introduced the ratified text into the legal national framework, ratification means that the text is ours. It is a commitment that we have taken freely and which we should abide by, because we have taken the commitment freely. This is the principle which is known by everybody, that is the pacta sunt servanda, meaning the force of the commitment that has been made. That is a state, meaning that the state which has ratified has taken the commitment of executing its obligation, honoring its obligation. A state that has ratified has committed itself to implement the text totally, because it can happen that it can decide to commit itself partially, but when it commits itself entirely, it must implement the text fully. This raises the question of what could be done to a state which has ratified, which has taken the commitment, but which doesn't abide by its commitments. And in legal terms, we say a state has not honored its commitment. When a state does not honor its commitment, we have a feeling that this state is not serious. And the picture that is reflected to the outside world for for making a commitment and not abiding by it could be a little bit a disastrous picture. This is the reason why ratification is an act of responsibility. A state which decides to assume its responsibilities, to commit itself and to commit its populations, and as soon as the ratification has been made, then there are avenues which are open as concerns the organization which is involved, where there are several benefits. I will not get back to these advantages. They have already been referred to in detail by the previous speaker. And to save time, I will skip that. But while skipping that, it seems to me that it is important to underline and get back to the fact that whenever we have not ratified, we are not entitled to speak or to be elected or to participate in electing somebody as part of the international organization involved.
So what happens is that one cannot vote, one cannot be elected, and the citizens suffer because they are on the margins of the process. The evolution today with globalization means that no one can be marginalized from evolution. I have said the following already, and this has been repeated. There are obligations, many obligations, and these are important. They are fundamental. We will not go back to the detail of these obligations. We, however, need to underline the fact that ratification is a responsible act because a state is ready to take advantage of the system it has ratified and also to bear obligations and adhere to obligations that it has freely given itself. Ratification, therefore, integrates us into a system. I can say that it is an act of integration, generally speaking. This act of integration is an act of responsibility. It's a responsible act. It is a privilege that those who have not ratified do not have. The results of ratification from a legal point of view are what I have mentioned. We cannot make the list here from a social point of view, cultural point of view, economic point of view, etc., because all of us need to be in the African Union system for the interest of our states and our citizens, our people. This is what we can say on the effects or results of ratification. Thank you.
Nous remercions Monsieur le Professeur.
We thank the professor for his presentation. I think that you will agree that this has been a very clear explanation on the results of ratification, commitment, responsibility, and integration. We have a few people who have asked for the floor. Mrs. Veronica from Mozambique, Mr. Ibrahim Ahmed from Sudan, Honorable Duimana from Burundi, Mr. Kadri from Western Sahara, Mr. Fernando from Angola, and Jacob Franci from Zimbabwe. I will make a comment on the Congolese example after the delegates have the floor. Mrs. Veronica first. 3 minutes.
Thank you very much, Mr. Chair. First of all, I'd like to thank the speakers, which, in fact, in a very succinct manner, in fact, spoke to us of the importance of the ratification. They also spoke to us of the benefits. Without any doubt, this is a very important theme, since African countries, in its efforts, in fact, towards democracy, towards inter-policies, and it is true that this African treaty is very important and has, in fact, adopted already instruments towards the harmonization of policies and also strategies towards the development of our continent. So it is within this context that we can see the ratification of this protocol. We welcome with great enthusiasm the creation of the Pan-African Parliament because we believe that this institution, which is in fact representative of the aspiration of its people, is in fact a privileged platform for those whom we represent, in fact, make their voices heard in the world, so that we can, in fact, be one Africa, one voice. Since its creation, the Pan-African Parliament has, of course, made enormous progress, and its existence is, in fact, a proof that democracy and rule of law in Africa is an irreversible process. The very profound debates which we hear here, which in fact address the economic challenges and also peace and development on the continent, as well as cross-cutting issues such as gender parity, are, of course, a demonstration of a very clear demonstration of the decisive importance of the role played by this organ towards the development of the economic development of this continent. Dear colleagues, despite all the progress made by the Pan-African Parliament in the playing of its role and faced with all the different challenges towards its ratification, such as the consolidation as of its administrative structure, the management of its resources, and also the consolidation of its existence and, in fact, its image, not only within the parliaments of the member states, but also amongst citizens, are, in fact, the very reason of its existence. As already has been very well said, we need to actually go beyond what is happening here, so that, in fact, we can actually go towards the ratification of the revised protocol. Speakers, ladies and gentlemen.
Votre contribution.
Thank you. The floor goes to Mr. Ibrahim Ahmed from Sudan.
بسم الله الرحمن الرحيم. شكرا سيد الرئيس.
Thank you, Mr. Chairman. I should like to begin by thanking the President of the Pan-African Parliament, who has always vouched for the speeding up of the ratification of the revised protocol. The President continued with his efforts, and we would like to thank him for it. Mr. Chairman, the need to ratify underlines the importance of our call for one Africa, one voice. This is why in Sudan, we underline the importance of the ratification of this protocol. We note that the ratification of the protocol also allows for a few reservations. But the reservations are not obstacle to ratification. A state can ratify while expressing reservations on the protocol. This is what we have done in Sudan. The state has ratified, expressing some reservations for Articles 4, 6, and 9. What is important is to ratify, and afterwards you can voice your reservations that can be taken into account when the process evolves. Mr. Chairman, very important statements have been made on the advantages and implications of ratification. This morning, an important statement was made by the Prime Minister of Lesotho. I should like to reaffirm what the Prime Minister of Lesotho has said, and it is very important for us as parliamentarians to understand all these statements, and this is why we need to move from talk to action and go to practical measures. This is why it's important for us to have a relationship between the Pan-African Parliament and national assemblies. This relationship needs to be coordinated, and there can be no discord or contradictory positions. Our people must support us as we continue to make efforts for the advancement of Africa. Also, regions must not be separated from their people. But what is the most important is or rather, as the Prime Minister of Lesotho said, what happened at the European Union. There is a lesson to be drawn from that, because indeed there is a comparison between modern times and post-modern times. We speak about integration between different peoples and elimination of boundaries and frontiers. So what has happened in Europe and Brexit will have implications for us in Africa. We have created an African Union. We have created a Pan-African Parliament. And Brexit will have an impact on what we have been building for the last couple of years. Will there be a new competition for Africa? Will there be a new conflict between Francophone and Anglophone countries? Let me be very brief. It's a very important issue indeed, Mr. Chairman, and we need to take it into account. We should like to draw your attention on this matter so that emerging African institutions do not suffer. Thank you, Mr. Chairman.
Merci de votre...
Thank you for your contribution, Mr. Ibrahim Ahmed. We give the floor to Honorable Andre Mana from Burundi. Thank you, Mr. Chairman, for giving me the floor. Let me start by thanking the organization, institution, for the welcome that has been bestowed upon us. I represent Mr. Pascal Yamenda, who has not been able to attend this meeting. Mr. Chairman, the Burundi Parliament congratulates the African Union for its will and success in guiding Africa in key areas like democracy, peace, security, and rights of the people. Burundi has decided to contribute to this process, and this is why we sign and ratify treaties of the African Union. Mr. Chairman, the adoption of the new protocol on the Pan-African Parliament discussed in 2015 in Malabo represents a fundamental change whose aim is to increase participation of the African peoples to its economic development. But we need to ask ourselves the following, as those who have spoken before me have done. Despite that are mentioned, there is a hesitation towards a ratification. I don't really have a solution for this hesitation, but I think that most African countries have been going through elections from 2013 and 2014, and that perhaps has been an obstacle to ratification. And many African countries are still in the electoral process. Perhaps I can also say that there is a feeling today that despite the good vision of the Constitutive Act of the African Union, which provides for a unique and strong Africa, we have many legal instruments, but we realize that most of our decisions and resolutions are guided by partners and those who fund our states. I should like to thank those who have rejected Resolution 2303 and thank the states who have shown solidarity towards Burundi. I think I had 1 minute left. I think that was not the first legal instrument, but we must be all aware and really say no to those who want to invade our countries. I have prepared a document that I will hand over to you. Unfortunately, we have the feeling that other legal instruments today are not applied correctly. Thank you. Thank you, Mr. Ndjimana, for your contribution. Mr. Gatri Adu from Western Sahara.
Bismillah ar-Rahman ar-Rahim. Sayyid al-Rais.
Mr. Chairman, ladies and gentlemen, we are very grateful to the President of the Pan-African Parliament and his team for all their efforts. We thank South Africa as well for the welcome bestowed upon us. Our Parliament has ratified on 29th May 2016 the protocol on the revised protocol on the Pan-African Parliament. Even if the submission through the usual channels has not been done, but the ratification has been done. That was preceded by a national dialogue that went beyond the debate in our parliament. This also went to an awareness campaign to advocate a free and united Africa, and the dream of a united Africa will materialize one day. This is something that the peoples have to guarantee. We are responsible for the future of Africa. We need to have the guarantee that we are advancing, that we are always going forward, and that we are envisaging a very positive future. So many conditions are necessary for this peace and security. Africa must have a united approach on peace based on justice. Also, the settlement of disputes and conflicts, and peace also and the fight against organized crime and terrorism. These collective efforts are necessary to realize these dreams. So I should like to appeal to all our brothers in all national and regional assemblies to join the Pan-African Parliament in order to support the effort of the African Union to set a date for the referendum in Sahrawi, the last colony, to allow the integration and help Morocco to adopt international instruments to stop this colonization. As a conclusion, Mr. Chairman, we are ready always for peace and justice, and we are always committed for building a united Africa. Thank you.
De votre intervention.
Thank you for your contribution, Mr. Katri Abdou. Mr. Fernando da Piedade from Angola has the floor.
Président de l'Assemblée. Oui. Interprète.
Yes, sir. No, we could not hear the gentleman if he did speak. Could the delegate try and speak again to see if we can hear him, because we haven't heard anything up to now.
1, 2, 1, 2.
Vamos começar a contagem. Sua Excelência, Senhor Presidente.
Your Excellency, President, Your Excellencies, members of Parliament, dear colleagues, ladies and gentlemen, accept my most cordial and warm greetings. And my wish is that this day of work help us find ways towards the growth and advancement of this very pertinent African Union institution. The history of any organization knows highs and lows, experiences which are more or less relevant. This as a result of the objectives which are rooted in a shared vision by all of us. The vision of the Pan-African Parliament is the vision of the African people, and is framed in the vision of the African Union and also Agenda 2063, where are highlighted the principles of democracy, respect for human rights, social justice, and the rule of law. Democracy in Africa is the result of very difficult processes, but is founded on a strong legal basis, which confer guarantees that its consolidation is a sine qua non condition for peace, stability, and the social progress of all its nations. The heads of state and government, aware of this wish, have agreed in the revision of the protocol which institutes the Pan-African Parliament in order to extend its competencies beyond the actual ones and focusing on the facilitating of the implementation of policies and the objectives of the African Union. As any other agreement or treaty, the implementation of the revised protocol demands that the countries create conditions for its approval and the introduction of all those legal instruments in the national judicial orders, which also required different procedures so as to guarantee its efficiency. Within this conformity, we considered that there are factors to be thought of faced with the diversity of our political systems and which in time will lead us to the uniformization or the harmonization in general. However, more than a decade has gone past since the running of this parliament, and I urge that we take very positive steps towards the concretization of these objectives so that the people we represent participate in the decision, in the taking of decisions to resolve problems and challenges faced by this continent. If there is no progress.
A nossa reflexão.
If there is, our thinking do take us to conclude and to suggest the following. The process of ratification of the revised protocol should continue to reflect the will of the heads of state and government who gave the green light towards the institution of the Pan-African Parliament and also towards its evolution towards new functions. The form and the extension of these competencies, of course, need to be evaluated and approved at the same level, since its implementation needs to, of course, obey the pace towards the realization of these new African institutions. Considering the actual text, it is not clear that the respect of the pace that needs to be applied and, in fact, I think we need to suggest measures to be taken. We need to present to the Summit of the Heads of State and Government a report on the status of the implementation of decisions taken during the 20th Summit of Malabo, 27th of June 2014, and that this practice be institutionalized as a permanent point in all the summit agendas. That also be identified all the difficulties or any factors which have led to the lack of success on the part of the member states of this Pan-African Parliament. I'm sorry you've gone beyond the time that has been allotted to you. Otherwise, we're giving the impression, in fact, we are favoring some and not others. Normally, we only accord 3 minutes. This is now well beyond 4 minutes. Unfortunately, we need to respect the timing. The following person is Jacob Francis Mudenda from Zimbabwe.
Thank you, Mr. President. I hope I'll be the last and the last shall be the first. Let me give you the experience of Zimbabwe and the issues that are raised, but let me also put a proviso that we are for the ratification, but there are issues that stand out. The first one, PAP is based on 5 regions. We should be 5 regional parliaments. And SADC PF is one of them, but it's not a regional parliament. So the first thing I think I would implore PAP to do is to assist SADC PF to be transformed into a regional parliament as a very important regional bloc. Second issue is the electoral process. It says under Article 5A, 1A, the national parliament or other deliberative body shall elect from outside its membership 5 members of the Pan-African Parliament. Now, what Zimbabwe has been trying to understand is if the national parliament elects those 5, what is the basis of that membership out of which the election shall stand? In other words, what is the electoral constituency upon which the national parliament shall elect those 5 members? Related to that, it is not clear as to what type of the deliberative body shall elect Perhaps PAP could give some form of procedural guidance as to really find out how do you structure that deliberate body and what authority shall it have in order to elect those 5 members to be members of the Pan-African Parliament. The other issue that has been raised is the question of the legislative responsibility of PAP. Zimbabwe has raised the issue of, fine, we can have PAP legislating. The issue is, how will these laws dovetail with the national laws? Secondly, what are the enforcement elements? In other words, the question of enforceability of those laws. And finally, the question of financial implication. Zimbabwe believes that the current setup where members are chosen from the National Assembly is more acceptable because the question of accountability does not arise. These members of parliament, the 5 of them, will account to the parliament of Zimbabwe. But as it stands now, if they don't account to the parliament of Zimbabwe, what are the financial implications in terms of making sure that these 5 members really are well looked after in terms of being members of PAP? I thank you.
Passons la parole à Monsieur Nelson.
We give the floor now to Mr. Nelson Makmabela.
I'm an observer. With the kind permission of my speaker, the issues I would like to flag have been raised by the honorable speaker from Zimbabwe. So I rest my case. Thanks.
La parole.
I would like to give the floor to, I think Madam Veronica, in fact, already has spoken. I also would like to address you within 30 minutes. Sorry, do you wish to take the floor? Because those, in fact, who took the floor have registered, so I will make an exception. I'll make an exception to, yes, okay, you have the floor, you can ask a question, and then there will be another question. Thank you.
Merci.
Yes.
Thank you very much, Mr. President. Yes, dear colleagues, I would like to thank the President of the Pan-African Parliament and all the members of Parliament here for the invitation which was sent to me, and also for the welcome we've received in this country. Mr. Chair, I am a Member of Parliament since 1998, and I am a great defender of sub-regional parliaments. So I am the president, in fact, of the ECOWAS Parliament. And I have often asked the question, and I would like to share with you this question, which I think is a very important question, to the president, also to the chairs of the, or to the speakers, in fact, of the national assemblies who are here. Today, do you feel a will? Do you feel a will from on the part of our leaders, of our African leaders, of our heads of state, to to want to, in fact, accord a part of their sovereignty to their regional parliaments and to national parliaments. And I would like to hear your views on this question, because we have, in fact, introduced a request. We have worked for years on an additional act with the view of going towards the strengthening of the prerogatives of the Parliament. Much money has been injected, in fact. The Ministers' Council has adopted it, but the heads of state, in fact, have not seen. What they did was put the paper aside and they say they're not ready. So I don't think we can really ask people to come here and to discuss issues that are of no interest to the heads of state. Thank you very much. Zambia, please, you have the floor.
Thank you very much, Chairperson, for allowing me to intervene. My question is directed to the Legal Counsel for the Commission. My name is Patrick Matibini. I'm the Speaker for the National Assembly of Zambia. And this is a point of clarification. I gathered from the presentation by the Legal Counsel that PAP has since transformed from an advisory body into a legislative body. And also indicated at some point during the presentation that PAP will now be able to legislate in areas where there's common agreement, which is a very positive assertion. But when one considers Article 8 of the Protocol to the Constitutive Act of the African Union, and more specifically in Clause 1A, it's very express on this point, namely, that it shall be the responsibility of PAP to propose draft model laws. Now, my question is this. Can we say in light of Article 1A, 1A, that indeed PAP will be performing a legislative function? If you are proposing model law, suggest that that may not be equivalent to legislative or legislation par excellence. I take that to mean simply advisory still, because you are proposing a model law. You are proposing a model law. And even if we were to legislate, even if we give the benefit of doubt that it's legislating, how are these laws anyway to take effect in view of all these challenges relating to sovereignty? How are these laws to take effect? So if they are not able to take effect, it simply means they are model laws. And if they are model laws, it means PAP is still performing an advisory function, because it is open out to the individual national parliament to either enact or not to enact. So it's simply providing advice. I would like to seek the Legal Counsel's clarification.
Votre intervention, nous aurons sûrement.
I would like to note that in Congo, concerning another issue, we have actually found a solution. When we were receiving ambassadors, I noticed, in fact, that various agreements, for example, of reciprocal protection of investments, had not, in fact, been deposited at the Assembly Nationale for ratification. So what did we do? What we did was that we sent a written question to the government, and we asked, why do you not deposit your such and such convention at the National Assembly to be negotiated and signed by the government? And I can tell you that just a little time afterwards, these conventions were, in fact, the instruments were deposited and they were ratified. So I think that's also perhaps a way of solving this problem, that we need to have parliamentary control so that the government, in fact, expresses itself when they are, in fact, blocking a lot of these conventions which need signing when we're speaking about the African Union. There you are. It took 1 minute and a half. The other minute and a half, I would also like to say that we also had another case, a very singular case, where a senator was, in fact, he demanded an authorization for ratification because the government was taking so much time. And in fact, we're still thinking about it because it's a prerogative that is, in fact, the government's prerogative, which has the power to determine the policies of the nation. Thank you very much.
Oui, le président de...
Yes. Sorry, you have the floor, sir.
Mr. Chairman, the Speaker of the ECOWAS Parliament has asked a very important question. We have to ponder that. The question here is, the heads of state of Africa, the presidents of our continent, are they really willing to surrender part of their sovereignty to a supranational body? If you ask me, and Mr. President of ECOWAS, if you ask me personally, much as I would not give a categorical no to that answer, I would say I have very serious doubts whether our presidents are really willing to surrender their sovereignty. And also, Mr. Chairman, the Speaker of Zambia asked a very important question, or made a very, very salient observation. And what is it? Even if ratification is to be made by all the African heads of state, we are still limited as a parliament. That is only to make model laws. As far as I'm concerned, that is only giving quasi-legislative power. And what we have been advocating for, I was a member of the Pan-African Parliament for about 6 to 7 years before I was subsequently elected Speaker of my country. And I want to say here, Mr. President of PAP, that all these years we have been shouting, we have been advocating, even agitating for full powers. But up to this time, there has been nothing. And I say to you, Mr. President, unless we try to sensitize our people more, or we try to talk to our individual presidents, ratification will not happen at all. And PAP will never have full, absolute, and unconditional legislative powers. Thank you very much.
Merci, Excellence, Monsieur.
Thank you very much, Excellency. I would like to give some sort of political answer. I will leave what is technical to the technicians. The problem of the Pan-African Parliament today is the issue of political will. Who decided, in fact, to institute the Pan-African Parliament? If we start with that, we can understand that what happened in 1963, in fact, when we were instituting the African Union in 1979, there was, in fact, another will to put other institutions in place. Everyone agreed. If you read, for example, the Tome Treaty or the Lomé Treaty, we can see that there is, in fact, a will to put in fact, have all these institutions. So if I'm now addressing you, it's because this revised protocol, when in fact, when we instituted the Parliament in 2004, the will was there. And then we thought after 5 years, the Parliament will be able to legislate, and everybody said fine, and that's what we did. From 2005, when in 2009, I've been speaking about it because, in fact, I've gone through this process from beginning to end, and I continue to do that. when we started saying that we needed to revise the protocol, we ourselves made proposals. We made proposals as a parliament. Everything was rejected. And in fact, our legal counsel is here. So we tried finding, as somebody said, then we need to find an exit. And our exit was what? Our proposals was, please allow us to legislate, allow us to control, without having an intervention. But the heads of state, of course, said, what? You want to legislate in the name of whom? Are we going to review our constitutions? You're going to take our powers? No, leave. So, of course, they rejected it. So the exit was what? The exit was yes, and in fact, the Zambian speaker, as you said, we're going to propose the model. We're going to propose model laws. And in order to suggest these model laws, it will be under the control of the heads of state. And there they said, okay, now you're speaking. Because it was, in fact, I who presented this. Whether it will be Addis Ababa or Malabo, and the speaker, in fact, of Zimbabwe, earlier on, during the last summit, he was there, and I went to see President Mugabe, and we spoke. We spoke. And he said, what, you're still there? Yes, I'm sorry, Chief, we're still here. But he said, well, oh, fine, I'm going to see. But know that that what you insist on, it will be a gradual process. That is what he said to me during the summit in Kigali. And almost all the heads of state of Africa were there. And I can say that there are a lot of reservations on their part, whether it be one or the other. Some are in favor, others say, no, we need to do this and we do that. And the point that has just been raised, for example, the designation of members, the salaries, etc. So this is why I ask you the question, you speakers, the money that you give us to come here to South Africa is to do what? We've got so many problems, and with all the risks that, in fact, people run here, we've got issues with crime. We've had people attacked. So how can we actually validate our presence here? So on a political basis, we're going to have to just sink ourselves, you know. So I do feel that we need to do something. Otherwise, this ratification will never ever take place if you do not commit yourselves. And I've already said it during the last summit. I met lots of heads of state. I saw them personally. I went country by country. Some said, yes, okay, we're going to do it, but tomorrow, then tomorrow becomes the day after. And I do believe that, yes, it is going to take time. And the national parliaments, which is the parliament that's not in crisis? Is there one parliament here that is not in crisis? That they can say, yes, we have all the funds that we can pay all the delegations, all the air tickets, for example. You know, we could perhaps take that money and put an end to malaria. So I think we need help. We need to ratify, and even if it's not implemented, because of course the model laws will of course bring another problem, because the moment we make a suggestion, in order to draft a law, we need at the conference or that accepts it. And once that is done, then we need to, of course, send it back to the Assembly of Heads of State, and then they have to say yes. And when the Assembly of Heads of State say yes, then it, of course, it has to go back to the national parliaments for ratification. So I don't really see. However, I think we need to change the statutes for us and for Africa. And I would like to end by saying that about 3 months ago, the Speaker of the European Parliament invited me to come. And when I arrived, he presented me like the big president, and I was the president of millions of people. But in fact, when we spoke, he said, but I've only got 500 million and I only represent, for example, a billion. You represent far more people. But at the end, the discussion was based on what? It was a demand of funds so that, in fact, we can continue our activities. So you see, people see you as a very, very big and large person, but in the end, we are too small because we don't have the funds. So I've already said it here, and all the heads of state know it. I had suggested very humbly, and we said, if we are not ready for a national parliament, for a continental parliament, then we need to stop, and then we need to invest elsewhere for the well-being of Africa. If you can help us also to go in that direction, then that's it. We suspend the Pan-African Parliament, that's it. That would also be an exit for us. Thank you very much.
Sont assez
Right. We've heard, I think we've heard everybody who needed to, and it is the President of the Pan-African Parliament who took a little bit more time to explain to us or to give us some more explanations. We have made reference to the issues of lack of security, but I must say that even when we go to France and Belgium, that can also happen there just as it happens here in South Africa. This is not an exception. It's not a specific South African issue. So now I think we're going to give the floor to both professors to be able to answer our questions. Thank you very much.
Thank you, Chairperson. There are specifically two questions. One from Honorable Speaker from Zimbabwe, and the clarification sought by the Honorable Speaker from the Zambia. Let me deal with the question from the Honorable Speaker from Zimbabwe in terms of Article 5, sub-Article A, in terms of the election outside the Parliament. And you asked the question, what is the electoral constituency for the election? Of course, each member state is assigned 5 members, and that constituency is determined by the state, which is sovereign, to be able to decide how people will represent it in the Pan-African Parliament. So the constituency should be worked out from domestic implementation by the state party in question. Then secondly, also the question as to which body should elect. It is very clear in Article 5 that the national parliament or the so-called any other deliberative body, which will be determined by, again, member state, is a temporary measure. Because if you look at Article 5.3, it says, until a code is developed for election to the Pan-African Parliament by direct universal suffrage, the procedure for the election to the Pan-African Parliament shall be determined by the national parliament or other deliberative body of such a member state. In other words, until we have the ability for all African states to engage in electing their parliamentarians directly, then the parliament of the national parliament or such other deliberative body shall determine how they will be elected. So that is an interim measure that, of course, is the full national election of these 5 people who will represent the state in the Pan-African Parliament. And then the question as to what is the law to be made relative to national law? How will they operate? And that will implicate my clarification to the question offered by the Honourable Speaker of Parliament. Now, when model laws are made, they are laws that are provided to be adopted in accordance with the national procedures of the member states. So they will hardly be in conflict. First of all, there will be laws that derive from common positions, and it is open to the member state to utilize them for its own purpose. It may well be that some member states are advanced beyond the model law provided. It may also be that others do not even have basic law in the area, and therefore could adopt them to be able to have national legislation in that. So there's no presupposition of any conflict whatsoever with national law. Now, in terms of financial implication, how will that work out? Because you prefer an arrangement whereby there is accountability. I raised this issue when I was received by the Honourable Speaker from Zambia, particularly when they were, which is almost at the backdrop of the amendment of their constitution. Now, let's assume that Zambia has 120 parliamentarians in its local parliament. I would expect that in providing for parliamentarians to go to the African Parliament, they will make provision for additional 5, which in this case will be 125, and allow them to have a desk nationally so that they can come back and report regularly in which case accountability is measured, because it is the expenses paid by the member state. I think this is the creativity that each member state can adopt to make accountability easier and to make budgeting much easier, because they are parliamentarians, but this time acting in the African continent. I think that will be a process through which you can get accountability as well as account for the financial implications of having African parliamentarians. Then to clarify the question from the Honorable Speaker, I didn't say the PAP has started. I said when the protocol enters into force, then PAP will begin to exercise legislative powers. Now, let's go into the merits of whether or not model laws are actually legislative powers. I think my presentation tried to balance the problem we had in Malabo. The question is, at the level of African integration, are we really ready to extinguish lawmaking powers of your national parliaments and give them all to PAP? We are not ready, by all implications. You will not even agree as speakers. How much more heads of states? Then what is the balance? Can parliamentarians therefore be confined to those areas where there will be mutual agreement? And to diffuse the sovereignty struggles, let them propose model laws. What are model laws? Well, I would think that parliamentarians will be very creative. A good model law will be adopted because it is good. And the persuasion is for member states to have laws in common areas. I've just given an example. I understand, I have not proved it, that there's a particular African country that has not made any law since 1870-something because of lack of capacity to draft laws. Now, assuming Parliament works the way it's supposed to work, is active in various areas, providing laws that will guide African continent, any reasonable member state, in my estimation, would adopt such laws because they are instrumental in having a legal framework for the country. I think it is an opportunity, in my view, for Parliament to incrementally begin to gain power and to impress our member states that norms can be developed by the Pan-African Parliament strong enough to persuade member states to adopt them. I think that is a good area to begin. Rather than say they will not give you full legislative powers to override national parliament. It's almost going to be impossible at this level of our integration. Remember when they were proposing the one authority, one African government, there were all kinds of those who said, let's do it in the immediate. They said, oh, no, it has to be a long-term process. Some said, never. It implicates this particular process. So my suggestion and my advice would be exploit the power of making model laws in those areas that you can be useful to transform the normative landscape domestically of African issues. I think that would be very persuasive, and there will be no reason why a state that needs help cannot look to the Pan-African Parliament on issues of common African interest. That is my suggestion. And as painful as it is, sovereignty is at stake, and not many states are willing. Brexit. Why is Brexit happening? Because some people in the UK felt Brussels, the Commission, was becoming too powerful, replacing national parliaments and making laws directly that affect them. So it becomes a basis for us to be creative. And I think the Pan-African Parliament can be very creative in various areas that are not controversial. And it is better that we work within the areas that are not controversial. Whether or not they are full or quasi-legislative powers, at least something says that they are legislative powers. Whether quasi or full, they are legislative powers, and they can be very persuasive if the laws are good. Thank you very much.
Merci, Monsieur le Président.
I thank you for insisting. I would like to insist on two things The protocol which we're talking about today has also been discussed in other countries and in other continents, and we, as university academics, have had the possibility of discussing it with other colleagues. As concerns the issue on Brexit, we have spoken about this protocol with friends from European countries. And as it was said by my colleague earlier, the Brexit has taken place because at the beginning there wasn't a will of conciliation, and the Treaty of Rome there was a willing to lay a legislation elaborated by technocrats. It must be clear. The African solution here has consisted in elaborating a consensus since the beginning, a consensus between, on the one hand, the heads of state, and I mean the states, and the African Union. And the solution of model laws is an intelligent one because it allows a collaboration. These are laws of collaboration. These are laws of collaboration for two reasons. First, at the level of areas, that is, the enhancement of areas which all the states have considered as common areas. This means that the African Parliament will not really work on the same areas as the national parliaments. It is the national parliaments and the national governments who will say that we will not work on such areas. So this is fundamental. It means that there will be no giving up of sovereignty. There is a will to see to it that we come up with joint solutions. This was fundamental. Something else which seems to me to be essential to say that we have evolved, taking into consideration the difficulties of others. The solutions that we are proposing as part of the PAP are solutions which take on board the problems which others have faced. And here I consider that when we ask that whether the heads of state agree, I must say that there are indicators. We have signed, several of these states have signed this protocol, even if they have not yet ratified it. This is already an expression of will. It is an important one. Something else, I do not remember, unless I'm mistaken, that a state has clearly stated to be against this principle. All the states have said that we agree. The principle of consent, which is known, and the protocol is here. If there was no approval, the protocol was not here, it wouldn't be here. We must have a minimum, we must give a minimum of good faith to our leaders. And the phenomenon is new, and there are explanations to be provided. There are stages to go through. There are convictions to be established before coming up before reaching the effective starting. And I will finish with this, Mr. Chairman, Mr. President. We must also admit that the protocol has only been revised in 2014. Several other protocols in other countries in the world has spent more than 10 years before being fully implemented. According to my reading, a neutral reading, which consists in wondering how long states will take in order to ratify, to reach the quota of ratification. I must tell you that in countries or in other continents, sometimes it takes 15 years or 20 years. Today, it's only 2 years, and we already have quite an interesting number of states, meaning that myself, I remain optimistic, and university academics are optimistic, and you have to assume the responsibility of history. Thank you. Thank you. On behalf of my colleagues, we would like to thank very sincerely the two professors who have enlightened us. And before taking the break, we're going to give the floor to the administration to provide us with some practical announcements. Thank you.
Thank you. Good afternoon, Excellencies. The first announcement is that there is a meeting of the Executive Committee of the Association of Secretary Generals, ASGAP, and this will take place at 2 p.m. In committee room number 8. You have about a few minutes. The second announcement is that all delegates of the Speakers Conference are invited to a lunch at the Gallagher Convention Center, which is next door. The speakers can use their vehicles, and the rest of the delegates can join the bus. So when you get outside in the front, there will be vehicles available to take you to the lunch at the Gallagher Convention next door. Thank you very much.
Heures.
What time are you?
It's 2 o'clock. A quarter to 2.
Are we continuing with the bureau?
Yes.
Or are we going to elect,
bureau, no.
Oh.
We have to draft. We are going to the